Nederlandse Tribunaal Penaal Internationaal pour lecture lui est ouverte. Please be seated.
Good morning, everyone. Yes, Ms. Peck.
Your Honours, if I may, I wanted to correct a matter on the transcript for the 30th of September. At transcript pages 47797 to 98, in answering Your Honour's question concerning the defence brief paragraph 2549, I said only individual C on Karadžić's list had been included in Dusan Jantz's total figure of 5977 identified individuals in the Srebrenica graves. In fact, individual D is also included in that figure, and for that I refer you to P4771, page 119, entry 132, and page 279, entry 20, and also Jantz's testimony at T26949 to 51 and 26965 and P4771 page 6. And Your Honour, similar to C, KDZ 045 only heard but did not see that D was killed in the woods, and the site is KDZ 045, and the transcript reference is 22678. I'm very grateful. That's the only matter.
Thank you, Ms. Peck. Yes, Mr. Karadžić. Oh, yes, Mr. Robinson.
Yes, Mr. President, I'll be addressing you at the beginning of this session. So, first of all, let me first answer the trial chamber's questions that were communicated to us last Friday by your legal officer. Most of the questions were directed to the prosecution, and I'll only address those that were expressly directed to us. But should the trial chamber wish to hear our position on any of the questions posed to the prosecution, please let us know, and Dr. Karadžić or I would be happy to address those questions. I think that Dr. Karadžić has already addressed your question number 2, at least twice yesterday, concerning efforts by Bosnian Serb authorities to control paramilitaries. With respect to question 7, concerning 2 victims from Brčko, you addressed your question to the prosecution, but you asked us on Tuesday whether we had any issue with the prosecution's explanation. We do. Now here's your question. You asked with respect to Brčko that the chamber had received death certificates P14 for P4411, P4412 from the bar table, which in the prosecution's submission were linked to incident B5.1, but there appears to be no other evidence linking these persons to the killing incident. And you asked, does the prosecution have any submission in this regard? And Mr. Tiger conceded that there was no evidence that the first victim died at Luka camp as charged in scheduled incident B5.1, but this is what he said with respect to the second victim. He said that the victim was among the victims buried in a mass grave in Brčko, which is listed in Avilash's 22 October report, P1607. And he said that Ristanić had agreed and testified that the victims in that report were non-Serb civilians who were killed in Brčko, including at Luka camp and similar places. And he cited P3023, paragraphs 220 to 223. But let's look at those exhibits. P1607, the report from Avilash, says simply that these people died during combat activities in Brčko. P3023 is the amalgamated statement of the prosecution witness, Mr. Ristanic. At paragraph 221, he stated that those were people who were killed by Jelicic and that sort of people, and some of those people actually died in combat activity. Then in paragraph 222, he was asked, "It's true, though, isn't it, that they've been killed and executed in and around Birchko, including places like Camp Luka, places in and around the police station, and other notorious killing sites?" And he said yes. Now, your question was about Schedule B5.1, which charges the killing of a number of men in Luka Camp between the 8th of May and the 6th of June, 1992. So do these two exhibits prove that the second victim was killed in Luka Camp? Absolutely not. There's clearly insufficient evidence to conclude that the victims died at Luka Prison, which is the only scheduled incident for Birchko. Now, for question number 9, you've asked us, in essence, whether our submissions on count 9 and 10 were intended to apply to alleged murders in Sarajevo charged in counts 5 and 6. And the answer is yes. Finally, in question 14, you've asked us about the impact of the prosecution's disclosure violations on any sentence that might be imposed upon Dr. Karadžić if he's convicted. As you know, on 73 occasions so far in this case, you've made a finding that the prosecution has violated its disclosure obligations. On some occasions, you recessed the trial for several months to give the defense time to prepare based upon the late disclosure. And you've asked us why those delays in Dr. Karadžić's trial ought to result in a reduction of his sentence when he would be given credit for the time he served during such delays in any event. However, it's our position that there is no correlation between the two. In those cases in which the appeals chamber or trial chamber have reduced a sentence for undue delay, the defendant has been given credit for the time served in any event. This includes the Barriaguiza case, known as Prosecutor versus Nahimana at the ICTY, involving a delay in bringing the accused before a judge after his arrest in Cameroon, and the Kajelajeli case, also from the ICTR, involving a delay in bringing the accused before a judge after his arrest in Benin. Both received significant sentence reductions for the violation of their rights, in addition to the credit for the time that they'd served. We say that it's important for the trial chamber to provide a remedy for the massive violations of the prosecution's disclosure obligations, not only to benefit Dr. Karadžić, but to send a clear message to this and future prosecution teams that such violations will not be tolerated. I would like now to talk to you about genocide. It's my respectful submission that Dr. Karadžić is not guilty of the genocide charges in count 1 and 2 of the indictment. Let's look at the definition of genocide. It's Article 4 of the ICTY statute, and it means any of the following acts committed with the intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such. And the pertinent acts for our case is killing members of the group, causing them serious bodily or mental harm, or deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. But it's this special intent to destroy the group that distinguishes genocide from other serious crimes, such as extermination and persecution. The appeals chamber has held that genocide is one of the worst crimes known to humankind, and its gravity is reflected in the stringent requirement of specific intent. Convictions for genocide can be entered only when that intent has been unequivocally established, and that's the Kirstic Appeals Judgment at paragraph 134. Now, count 1 charges Dr. Karadžić with genocide in 7 municipalities during 1992: Bratunac, Foča, Cluj, Preador, Sanski Mosque, Vlasenica, and Zvornik. After the prosecution had presented all of its evidence, this trial chamber ruled that there was no evidence upon which a reasonable trier of fact could find that the acts of killing, serious bodily or mental harm, and conditions of life inflicted on the Bosnian Muslims and/or the Bosnian Croats in the municipalities were perpetrated with the intent to destroy required for genocide. And it's our submission that nothing has occurred which would cause the chamber to change its mind about the prosecution's evidence. One thing that did occur was that the appeals chamber reversed the decision of the trial chamber and held that there was some evidence on the record which, taken at its highest, could support a finding of an intent to destroy on behalf of Dr. Karadžić and other members of the alleged joint criminal enterprise. The first question, then, is what is the impact of the appeals chamber's judgment on the decision to be made by the trial chamber at the end of the case? The appeals chamber itself emphasized that a judgment of acquittal.
Just a second. Mr. Robinson, bearing in mind the translation, if you could slow down a bit further.
Yes.
Please continue.
The appeals chamber itself emphasized that a judgment of acquittal at the end of the prosecution case should only be entered when there was no evidence capable of supporting a conviction, that its conclusions regarding evidence before the trial chamber are taken at the highest, and that the question of whether the evidence would meet the standard of beyond a reasonable doubt remained open. It's our submission that the prosecutor's evidence, while sufficient to overcome a motion for judgment of acquittal at the end of its own case, is insufficient to sustain a conviction requiring proof beyond a reasonable doubt. And it's useful to look briefly at the evidence that the appeals chamber cited as examples of possible genocidal intent. It specifically referred to evidence of prosecution witness KDZ 051, a Bosnian Muslim detained in Veljko Vlahović School in Rogatica, who claimed that he was told by Sveto Veselinović, a Bosnian Serb municipal leader, that during meetings with Dr. Karadžić, it had been decided that 1/3 of the Muslims would be killed, 1/3 would be converted to the Orthodox religion, and 1/3 would leave on their own. Now, understandably, in its final brief, the prosecution no longer relies on this hearsay evidence to establish genocidal intent. This is Sveto Veselinović. He came and testified during the defense case. He said that he was never at the Veljko Vlahović school, he never made such a statement, and that he never heard Dr. Karadžić make such a statement. Therefore, the evidence from witness KDZ 051 cannot support a finding of genocidal intent beyond a reasonable doubt. The appeals chamber also relied upon a statement made at the Bosnian Serb Assembly on the 24th, 26th of July, 1992 by Dr. Karadžić, that there was some truth to what had been said, presumably by a deputy named Miladin Nedić. Mr. Nedić had said that the Muslims have been planted to us as a people whose executioners we are to be. Now, while one reasonable inference from this evidence is that Dr. Karadžić found some truth in the idea that European governments were trying to manipulate the Serbs, which was the thrust of Nedić's remarks, in fact, Mr. Nedić came and testified during the defense case. He testified that he in no way advocated genocide against the Muslims. If he didn't understand it that way, how could Dr. Karadžić? The appeals chamber also cited to statements made by Dr. Karadžić about what would happen if the war started in Bosnia. These statements are now what the prosecution relies on to prove his genocidal intent. They include intercepted conversations in September and October 1991 with Momčilo Karadžić, Gojko Dogo, and an unknown person from the Krajina, where Dr. Karadžić says that if the war starts in Bosnia, the Muslims would disappear. Dr. Karadžić made a similar statement at the Bosnian Assembly session of 15 October 1991, where he said that the Muslims were inviting a highway of hell and possible extinction because the Muslim people would not be able to defend itself if war broke out. It's our submission that it's a more reasonable inference from the context of these statements that Dr. Karadžić was trying to convince the Muslims not to start a war and to reach a peaceful solution, not making a public and private call for the extermination of the Bosnian Muslims as such. You alluded to this interpretation in your decision at the end of the prosecution's case, when you found that notwithstanding these statements, there was no evidence of genocidal intent. And you were not alone. These very same statements were admitted into evidence in the Berginen and Karadžić cases. This is a table showing the exhibit numbers of these statements, in our case, the Karadžić case, and the Berginen case. And the trial chambers in those cases unanimously held that these statements were not indicative of genocidal intent. This same evidence was also considered by the International Court of Justice in the case of Bosnia versus Serbia. That court, too, found that a pattern of conduct on the part of the leadership of Republika Srpska, from which genocidal intent could be inferred, had not been established. As you know, at this stage of the case, the prosecution has the burden of proving that an intention to destroy the Bosnian Muslims or Croats is the only reasonable inference that can be drawn from the evidence. And while the trial chamber is not bound by the decisions in these other cases, although based on the same evidence, they demonstrate that one reasonable inference from the evidence before this trial chamber is that Dr. Karadžić's remarks were made to avoid war and not to promote genocide. In fact, you took judicial notice of 625 adjudicated facts from the Karadžić case and 301 adjudicated facts from the Berginen case. You had sufficient confidence in the conclusions of those chambers to reliably import those findings into our case. Would it not be incongruous, if not incomprehensible, for you to now find that their conclusion on the same evidence that Dr. Karadžić and the Bosnian Serb leadership had no genocidal intent was not even a reasonable one? For all of those reasons, I respectfully submit that Dr. Karadžić is not guilty of genocide as charged in count 1 of the indictment. You can find a more detailed analysis of the evidence, municipality by municipality, witness by witness, in the respondent's brief that we filed before the appeals chamber on the 5th of November, 2012. Now, that filing also acknowledges that crimes such as murder and infliction of serious harm were committed during the 1992 events in the municipalities of Bosnia. And I would be remiss in concluding this submission if I did not at the same time acknowledge that there were indeed many innocent victims of these crimes. A finding by the trial chamber, like the findings of the trial chambers in Stakic, Berginen, and Karadžić cases, and the International Court of Justice, that genocide was not committed in the municipalities of Bosnia in 1992, in no way diminishes the suffering of the victims or what they or their families endured during that terrible time. It simply reflects that the legal requirements for this very specific crime, requiring a very specific intent to destroy the group as such, have not been met. Even after what happened to the Jews in the Holocaust, the Supreme Court of Israel found Adolf Eichmann not guilty of genocide for crimes in the 2-year period where the Jews were deported rather than exterminated. What happened in Bosnia in 1992, while awful, was not genocide, and Dr. Karadžić should likewise be found not guilty of count 1. I'd now like to turn to count 2 and Dr. Karadžić's individual responsibility for genocide in connection with the July 1995 Srebrenica events. And this is a matter of life or death. If you're convinced that Dr. Karadžić planned or ordered the execution of thousands of prisoners from Srebrenica as part of some joint criminal enterprise with General Mladić, as the prosecution claims, then you should give him a sentence that ensures that he too dies as a prisoner, like
Kindly slow down for the interpreters, please.
the fields of Branjevo Farm, Petkovsky Dam, or near the Orahović School. But you would be doing a great injustice, because the truth is that Radovan Karadžić never planned or ordered these executions. And if you agree to the legal lynching of Radovan Karadžić urged upon you by the prosecution, an innocent man will have been convicted of a crime he did not commit. And I'm here to try to convince you with all of the force that I can muster while speaking slowly for the interpreters not to do that. And I'm passionate in this. We've put everything into our final brief that could possibly explain and deal with the issue of Dr. Karadžić's responsibility for genocide at Srebrenica as charged in count 2. And I stand here to implore you, as I plead Dr. Karadžić's case and for his life, to ask me any and all questions you have so I can clear out the smoke that the prosecution has created to mask the weakness of its case on this count. Let's start with something that's not in dispute. Not a single witness has testified that Radovan Karadžić planned, ordered, or was even informed about the execution of prisoners from Srebrenica. Think about that. And you have to ask yourselves why. Maybe one reason is that it simply isn't true. Radovan Karadžić never planned, ordered, or was even informed about the execution of prisoners from Srebrenica. Despite having unprecedented access to thousands of intercepted private conversations, thousands of written communications of the Republika Srpska military, police, and political organs, and hundreds of speeches and interviews of Dr. Karadžić, there's not a single piece of evidence that Dr. Karadžić planned, ordered, or even was informed about the execution of prisoners from Srebrenica. Srebrenica is the most well-documented crime in any war crimes tribunal since Nuremberg. You can follow the events of July 1995 minute by minute, place by place, through intercepts, satellite imagery, written reports, orders, and logbook entries. Yet there's not a single piece of evidence that shows that Dr. Karadžić planned or ordered the execution of prisoners from Srebrenica, or that he even knew that they would be, were being, or had been executed. The prosecution's case relies solely on inference. Dr. Karadžić was the president of Republika Srpska and commander-in-chief of the Bosnian army. He was closely following the Srebrenica events, and he issued orders during those events to the army, to the police, and to the civilian authorities of Srebrenica. Therefore, he must have planned and ordered the execution which followed. But we submit to you that that is not the only reasonable inference that can be drawn from this evidence. Another more reasonable inference is that Dr. Karadžić never planned or ordered those executions, and that in fact they were concealed from him and that he is not guilty of genocide. The appeals chamber has repeatedly held that when the prosecution relies upon proof of the state of mind of an accused by inference, that inference must be the only reasonable inference available on the evidence. And they said that the benefit of the doubt must always go to the accused. The defense case doesn't rely on inference. We brought everybody who could possibly speak to Dr. Karadžić's actions and knowledge of the Srebrenica events to come and testify at this trial. People who worked for him in his office, held meetings with him, and even those convicted of participating in the crimes themselves were brought to this courtroom, sometimes willingly, sometimes kicking and screaming by subpoena. But to a man, they testified that Dr. Karadžić was not informed of those executions and played no role in their commission. The scales of justice on this issue are unbalanced. The prosecutor's case is supported solely by inference. The defense case is supported by hard evidence. Now, I'm sorry to have to do this orally in such detail, but since we didn't have the right to file a written reply to the prosecutor's final brief, let me take some minutes to deconstruct, brick by brick, the prosecution's house of inferences that comprises its case for genocide against Dr. Karadžić in connection with Srebrenica. Fact. On the 9th of
Now, please continue.
Very well. Fact. On the 9th of July, 1995, Dr. Karadžić ordered the VRS to take the town of Srebrenica and ordered them to offer maximum protection and safety to the civilian population and to treat the civilian members of the population and war prisoners in accordance with the Geneva Conventions. The prosecution's inference is that this order facilitated the plan to execute the men of Srebrenica and was part of repeated efforts to cloak written orders implementing illegal objectives with simulated adherence to international law. We submit that another reasonable inference is that the order meant what it said, that Dr. Karadžić had no intention that civilians or prisoners be mistreated, let alone murdered. Fact. In the late evening of 11 July, Dr. Karadžić issued an order appointing Miroslav Derenic, civilian commissioner. His order provided that the commissioner shall ensure that all civilian and military organs treat all citizens who participated in combat against the Army of Republika Srpska as prisoners of war, and ensure that the civilian population can freely choose where they will live or move to. Fact. At the same time, Dr. Karadžić issued an order for the establishment of a public security station in Srebrenica. His order provided that all citizens who participated in combat activities against the Serb army will be treated as prisoners of war and in accordance with the law and with international conventions. Others will be free to choose their place of residence or place of emigration. The prosecution wants you to infer that this was another simulation of adherence to law that belied Karadžić's true intent that the men from Srebrenica be executed. We say there's another reasonable inference, that the order meant what it said, that Dr. Karadžić had no intention that civilians or prisoners be mistreated, let alone murdered. Fact. On the evening of 11 July 1995, Dr. Karadžić issued an order concerning the passage of humanitarian convoys through the territory of Republika Srpska. That's P5183, and I ask you to study that. The aim stated in the order was to eliminate problems in the passage of UN convoys. The prosecution would like you to infer that this order became a means by which Karadžić controlled access to the enclave by international organizations including UNHCR and ICRC, allowing the murder operation to proceed unchecked. We say that another reasonable inference is clear that the purpose of the order was to improve the passage of convoys, not to hinder them, as evidenced by the reference to the danger of international intervention because of the need to get humanitarian aid to affected civilians and the threat of punishment for anyone obstructing the convoys. The order loosened restrictions by prohibiting inspections and providing an escort between the border and the front line. Having taken the drastic action of overrunning a UN safe area, Dr. Karadžić wanted to make sure that there were no reasons for NATO to use force on the grounds that humanitarian aid could not reach the affected people. Fact. Dr. Karadžić met with Deputy Minister of Interior Tomo Kovač from 1550 to 1610 on the 13th of July, and again on 14 July from 2245 to 2310. The prosecution inference is that Karadžić met with Kovač on the 13th of July, sent him to arrange the logistics of the murder operation with General Mladić, and then Kovač reported back to him on the 14th of July. We say that another reasonable inference is that Kovač never received instructions from Dr. Karadžić concerning the murder of Muslim prisoners and never informed Dr. Karadžić of any executions. And we point out that there is no written order or intercepted communication indicating that Kovač had anything to do with arranging the logistics of the murder operation. Kovač's testimony was unequivocal that he had not participated in the murder operation nor discussed any killings with Dr. Karadžić. If Kovač was supposed to arrange the logistics of the murder operation with Mladić, how does that explain his order on the 14th of July that the police were to have nothing to do with the prisoners? And we have testimony of that not only from Kovač, but from Borovčinin and Mane Đurić. Borovčinin is paragraph 41 of his amalgamated statement at D 3659, and Mane Đurić, his testimony is at page 35043 and 44 of the transcript. But most important, what about that intercepted call between Biara and Krstić on the morning of the 15th of July, P5074, when Colonel Biara complained that MUP won't do anything? Fact. Dr. Karadžić spoke with Miroslav Deranic on 13 July at 2010. Deranic informed him that they had 2,000 and that there would be more during the night. Dr. Karadžić said that all goods must be placed in the warehouses by 12 tomorrow, not in warehouses there, but somewhere else. Doronich said he understood. The prosecution's inference that they would like you to draw is that Karadžić's phone call with Doronich, telling him that the prisoner had to be placed somewhere else, referred to Zvornik. We think there's another reasonable inference, that Dr. Karadžić was referring to Batkovići prison, which was the normal place for prisoners to be taken. How could Doronich possibly understand from this conversation that prisoners were to be sent to Zvornik? It's a more reasonable inference that if Dr. Karadžić was referring to any specific location at all, he was referring to Batkovići prison, a place to which the ICRC had regular access. And Milenko Todorović testified that they received instructions at one point to prepare Batkovići prison to receive prisoners from Srebrenica. You can find that at D4124 at pages 129, 34, 38, 39, and 41. The use of code on unsecure lines when referring to the location of prisoners was likewise not nefarious, but so that the enemy would not know where they were being held and mount a rescue operation in our submission. Fact. On 14 July, Dr. Karadžić issued a decision proclaiming a state of war in Srebrenica, Skalani municipality. The decision indicates that the aim of proclaiming a state of war is to enable the full engagement of human and material resources in the defense of the Republic and final victory over the enemy. It further provided that the armed forces and government organs shall observe the provisions of international law and international conventions regulating the conduct of a state during a state of war. The prosecution wants you to infer that Karadžić issued this decision to give Doronich extraordinary powers and to facilitate the use of civilian personnel and equipment for the murder and burial operations. And they claim that the column no longer posed such a threat to Srebrenica and Skalani so as to justify this decision. We say that another reasonable inference is that the aim of the decision was, as it is stated, to mobilize resources to defend the municipality. Exhibit P2803 at line 340, the Republic Communication Center log, indicates that this decision was issued at 11:55 a.m. on the 14th of July. On the morning of the 14th of July, the chaos in the woods around Srebrenica still existed, and the VRS reported that its units were scouring the terrain around Srebrenica. That's the daily combat report received early that morning, P4464, at page 3. Robert Đurđević testified that when he met with President Karadžić in the afternoon of the 14th of July, the army was reporting that there was a lot of fighting between Konjević Polje and Kasaba. This had nothing to do with murders and burials. If Dr. Karadžić had indeed ordered the transport of the prisoners to Zvornik on the evening of the 13th of July to kill them, as the prosecution claims, and wanted to conceal murders and burials, the order would have included Zvornik municipality. Fact. On the 16th, and this deals with the corridor, the opening of the corridor. On the 16th of July at 15:29, someone from the VRS main staff called the duty officer of the Drina Corps and said, quote, "I have to get permission from the main boss, from the main head of state." And he asked him to have Vinko tell you what happened and send it right away. In fact, on 16:15 of the same day, less than an hour later, the VRS main staff duty officer informed General Mladic that the president had called a short while ago and said that he'd been informed by Karadžić that Pandurović arranged passage for the Muslims over to that territory. and those are exhibits P5076 and D2002. The prosecution's inference is that Karadžić's call to the VRS about opening a corridor revealed that he was concerned about Muslims getting away while the killing and burial operations in Zvornik were proceeding as planned. And yesterday they told us that the main staff had to get permission because the opening of a corridor was a variation from the plan to kill all the Muslims of Srebrenica. We think that another reasonable inference from these conversations was that Dr. Karadžić was in favor of opening the corridor. His inquiry was prompted by a call from Karadžić. As you've heard from a protected witness, and you can find this at P4563, page 3, Dragomir Vasic, Karadžić's subordinate, was in favor of opening the corridor. Karadžić himself was personally engaged in trying to get the captured policemen returned safely across the line. His call to Karadžić would likely have been to encourage him to support Penderovic's opening of the corridor. Karadžić spoke favorably about opening the corridor during his 17 July interview with David Frost. You saw that yesterday. And that's P5235, pages 2 and 3 of the transcript. President Karadžić's discussion about opening the corridor at the 6th August 1995 Assembly session was made in the context of trying to fire General Mladić. He complained about combat tactics, spending time in Žepa without leaving sufficient troops to battle the forces from Srebrenica and taking many losses of life as a result. And that's P1412 at page 17. But even if President Karadžić was opposed to opening of the corridor from the beginning, so what? The prosecution has conceded that the column was a legitimate military target and could be attacked. There's nothing genocidal in inflicting as many losses on combatants as possible. This had nothing to do with the fate of the prisoners. Just another straw that the prosecution is grasping at. Fact. As reported by the Bratanic Brigade on 18 July, Dr. Karadžić had pardoned all the local staff who worked for UNPROFOR, and they were not detained. The prosecution's inference is that without Karadžić's amnesty, the UN local staff would have been killed, and Karadžić's control over the murder operation was such that he had the power of life or death over the Muslim men and boys of Srebrenica. We think another reasonable inference is that Karadžić did not favor or condone any killings and did not have the intent to destroy the Bosnian Muslim group. This is an example that no good deed goes unpunished in the eyes of the prosecution. Fact. The ICRC gained access to Batkovići camp on the 26th of July and the Srebrenica-Bratanac area on the 27th of July. And this is P2284, the UN report on Srebrenica, at paragraph 409. The prosecution wants you to infer that Karadžić either ignored or rejected requests by the UN and international organizations for access to the Srebrenica and Bratanac areas. Another reasonable inference is that the first letter requesting such access from Mr. Mazowiecki was sent to Dr. Karadžić on the 25th of July. That's P6396. And they got access the next day. Fact. On the 2nd of August, Biara and Stevo from the main staff discussed getting the Muslims who were detained in Srebrenica back to Republika Srpska. Stevo said that the ICRC was registering them, and Biara said, "We had no plans to kill them, just exchange them. You think it would be no good if Karadžić or someone else, and then it trailed off. This is P4972 at page 4. The prosecution's inference is that Karadžić approved efforts to retrieve Muslims from Syria to make up for a lack of prisoners to exchange. And they say Biara referred to Karadžić in this conversation.
I think you meant Serbia, not Syria.
Yes, if I said Syria, I'm mistaken. Sorry about that. We say that another reasonable inference is that there's no evidence that Karadžić had anything to do with retrieving Muslims from Serbia or had any knowledge of a shortage of prisoners from Srebrenica. Biara may well have been saying that it would be no good if Karadžić agreed to exchanges and then the lack of prisoners from Srebrenica became known. We think that this shows that Karadžić had no knowledge that the prisoners would be executed or had been executed. And there were reasons for people in the VRS to have concealed executions from President Karadžić. He had held them back from taking Srebrenica in 1993, and he had insisted that they withdraw from Mount Igman in August of 1993 in the sharpest of terms, as you've heard from those intercepts at that period. And he held them back from taking Goražde in April 1994. He had issued dozens of orders insisting that they comply with international law. They knew he would never approve of executing prisoners and that he would view such a thing as treason against Republika Srpska, which he does. Fact. On the 12th of August 1995, the Republika Srpska Commission for Exchange of Prisoners reported that a large number of Muslim soldiers had now been captured across Republika Srpska and proposed a one-for-one exchange. And this is exhibit P4975. They said that the Muslims detained in Batkovići could be freed in exchange for 170 Serbs held prisoner in the Tuzla area. They proposed to get Serbs held captive in Sarajevo by exchanging even more Muslim prisoners, quote, captured during the activities of liberation of Srebrenica and Žepa. And finally, they proposed to get Serbs held in the Zenica area by exchanging Muslims held by the 1st Krajina Corps, supplemented by prisoners from other areas of Republika Srpska. And I ask you to look at that document carefully. The prosecution's inference is that Karadžić received a report from the State Commission which said that there were no more than a few hundred Muslim men from Srebrenica at Batkovići camp. But we say that the other reasonable inference to be drawn from this evidence is that there were a large number of Muslim prisoners available for exchange. There was nothing in this report that would lead Dr. Karadžić to believe that there was a shortage of prisoners from Srebrenica. Quite the contrary. And that's it. That's the prosecution's case against Dr. Karadžić for Srebrenica. And as thin as it is to begin with, it simply falls apart when separating fact from inference and when determining whether the inferences that the prosecution seeks to draw are the only reasonable inferences from the evidence. Taken individually and collectively, the prosecution's case is insufficient to establish beyond a reasonable doubt that Dr. Karadžić was part of a joint criminal enterprise to eliminate the men of Srebrenica or even had knowledge of their execution. Contrast that with the defense case. You know how difficult it is to prove a negative. Yet 28 witnesses testified that Dr. Karadžić was not informed of the Srebrenica executions. Those witnesses included high-ranking officials in the army, the police, the secret services, and the assembly. They included a Canadian intelligence officer, witness KW554, who went looking through intelligence reports to see what involvement Dr. Karadžić had in the executions, and found that he had none. As you know from litigation before this chamber, Dr. Karadžić, at his own initiative, requested from a number of countries, including the United States, the United Kingdom, France, Germany, and Canada, any evidence they had reflecting his knowledge of the executions at Srebrenica. He did that because he knew the truth, that he had no knowledge of those executions. And his position is confirmed by the fact that not a single country produced even a scrap of evidence showing that Dr. Karadžić had knowledge of the executions, much less planned or ordered them. If Dr. Karadžić were truly guilty of the Srebrenica killings, you would have heard something more than what the prosecution has presented in 5 years of trial. And you certainly would not have heard the massive evidence presented by the defense on this issue. The prosecution has never explained why, if Dr. Karadžić had planned, ordered, or even had knowledge of the Srebrenica executions, he went out of his way to take credit for the Srebrenica operation, both on national television on the 4th of August, when he said General Karadžić had planned the Srebrenica operation in front of him, and at the assembly on the 16th of October, 1995, when he had said that he personally supervised the plan and personally ordered General Karadžić to take Srebrenica. A lot of bad things have been said about Dr. Karadžić, but nobody ever said that he's stupid. But even if you somehow believe that Dr. Karadžić had knowledge that the men of Srebrenica were executed, you must still find him not guilty of genocide, because genocide requires something more, that Dr. Karadžić had the intent to destroy the Bosnian Muslims as such. And as we saw with count 1, there is no evidence that Dr. Karadžić had that intent, not in 1992, not in 1995. For aiding and abetting genocide, Dr. Karadžić would have to have known of the genocidal intent of others. Yet the evidence that has been found in other cases at this tribunal to support a finding that genocide was committed at Srebrenica was unknown to Dr. Karadžić. In the Karadžić case, the trial chamber found that the fact that the VRS sought to kill every Muslim man it could find, civilian or military, was indicative of an intent to destroy the group. There's no evidence from which it can be inferred that President Karadžić knew that the VRS had sought to kill every man from Srebrenica. In fact, he was informed that the VRS had opened a corridor so that men from Srebrenica could proceed to Muslim territory, and he himself ordered the local Muslim UN staff from Srebrenica to be allowed to leave. The Karadžić trial chamber also based its finding of an intent to destroy on the concealment of the bodies and the prevention of proper burials for those who were killed. There's no evidence of any of this being brought to President Karadžić's attention. The appeals chamber found that General Karadžić's knowledge of genocide could not be inferred from his contacts with General Mladić, which were substantial, his participation in the Hotel Fontana meeting, his presence in Potocari, his order to secure the road where men were removed from buses, and the participation of members of the Drina Corps in the executions. President Karadžić did not have any of these contacts in Srebrenica, and therefore had even less reason to know of the genocidal intent of some VRS officers, if that intent existed. In the Blagojevich case, the trial chamber inferred that Blagojevich knew of the genocidal intent of those participating in the executions, primarily from his knowledge of the transfer of women and children, the executions in Bratunac's town, and that his forces were trying to capture Muslim men and prevent them from reaching Muslim territory. But the appeals chamber reversed this finding, concluding that without knowledge of the mass killings, Blagojevich did not have knowledge of the perpetrator's genocidal intent. President Karadžić had even less information than Colonel Blagojevich. Therefore, the Blagojevich case supports a finding that the evidence is insufficient to infer knowledge of genocide by President Karadžić. In the Popovich case, the trial chamber found that despite Commander Vinko Penderovich's direct knowledge of the murder operation, there was no evidence he knew of the key features of the operation indicating genocidal intent: the indiscriminate separations in Potachari, the vigorous pursuit of every last Muslim male along the Bratinets-Konevich-Poli road, the large component of civilians amongst the prisoners, the details of the executions, or the systematic nature of the operation. Likewise, President Karadžić did not know Colonel Biara or Lieutenant Colonel Popovich, nor did he have any contact with them. None of the information he received indicated that there had been any indiscriminate separations in Potachari, vigorous pursuit of every last Muslim male, or failure to distinguish between civilians and soldiers. Therefore, he had no reason to know of any of the facts indicating the killings had been perpetrated with genocidal intent. The Popovich trial chamber also found that Lubomir Borovchinin had no reason to know of the genocidal intent with which the crimes were committed, despite his being on the scene and having actual knowledge of the Kravitsa warehouse killings, and acquitted him of genocide. The information brought to President Karadžić's attention after the fact was not as encompassing or specific as that possessed by Borovchinin. Therefore, he too must be acquitted of genocide, even if you find that he had some information about murders. Let me once again make it clear that unspeakable crimes were committed after the fall of Srebrenica in July 1995. Thousands of Bosnian Muslim prisoners were executed, and the victims of those crimes never had any chance for justice. They were summarily executed by the likes of Franz Koss and Dražen Erdemović, without a lawyer, without a trial, and without a verdict. Dr. Karadžić has had a defense team, a 5-year trial, and will have a verdict from 3 learned international judges. That's a testament to the humanity of mankind, and I'm proud to have been part of these proceedings. This trial has already established the principle that as a society, no matter how heinous the crime, we value justice over barbarity. But just as it was a grave injustice to condemn the victims of Srebrenica, it would be a grave injustice to condemn Dr. Karadžić for crimes he did not commit. And genocide is one of those crimes. Therefore, I asked you to find Dr. Karadžić not guilty on count 2. Thank you.
Thank you, Mr. Robinson. We'll have a break for an hour and resume and for 20 minutes, and we'll continue at 10:20.
All rise. Feu vous levez.